It's about 5 months since President Bola Tinubu was sworn in as the President of the Federal Republic of Nigeria on May 29, 2023. However, the legal challenge against his electoral victory is still on at the courts. It is against this backdrop that political experts and analysts believe it is high time the National Assembly moves a motion to regulate the electoral process in such a way that all legal battles be concluded before the swearing-in of elected public office holders. This comes following the legal fireworks by major presidential candidates Atiku, Abubakar and Peter Obi challenging the victory of Tinubu, which the Supreme Court has reserved judgment after the duo appealed the Presidential Petition Tribunal judgment. To discuss this, we're joined by Omare, legal practitioner. Thank you very much for giving us your time. What legal provisions exist in Nigeria's constitution and electoral laws to address the prolonged legal challenges by opposition candidates seeking to nullify the results of the presidential election, and how do they affect the electoral process?
Thank you for having me on your program. Well, under our constitution, there is a time frame for the presentation of an election petition arising from a presidential election, governorship, National Assembly elections, and of course, state houses of assembly election. Now, with respect to the presidential election, the constitution says that within 21 days after the declaration of the result, the petitions have been filed by any party that disagreed. And the Court of Appeal is automatically the court that is constitutionally empowered to hear cases arising from a presidential election. When a petition is presented to the Court of Appeal as a presidential election petition court has 6 months, 180 days within which to resolve the dispute. Now, after the resolution by the Court of Appeal, any party that disagrees has the option to appeal to the Supreme Court as the highest court, and the Supreme Court has a constitutional responsibility to resolve the dispute within 60 days, which is 2 months from the date of delivery of the Court of Appeal judgment as a presidential election tribunal. So the period essentially is 8 months within which to resolve dispute arising from a presidential election. And the same thing applies to state houses of assembly and national assembly as well. But it's different with respect to governorship election, because governorship election moves from the tribunal to the Court of Appeal, then from the Court of Appeal to the Supreme Court. Now, how did we get here? The idea of introducing time frame within which to resolve election disputes started in the Second Republic. Then what the National Assembly did was to include it in the Electoral Act. But that provision was struck down. By that, we mean the court said it was illegal in that the National Assembly cannot tell the judiciary what the time frame within which to perform their statutory responsibility because of the principle of separation of power. So under the present democratic dispensation, what the National Assembly did was to exercise their power of amending the Constitution. So to demonstrate how serious that issue has been, the first alteration to the Constitution in the year 2010 was the amendment of the Constitution to introduce time frame, which I have just stated a while ago. So this issue has been a source of concern. The National Assembly addressed it through a constitutional amendment in the year 2010. But it seems that there is need to take a second look at it. But at this moment, what I've said is a time frame within which to resolve election disputes in Nigeria.
I really needed to let you explain that, because a lot of people are really concerned. I'm sure you're expressing similar worries as to how it is affecting our electoral process and the impact of these whole back and forth on governance. So I want you to speak a little on that. What is the impact of these delays, if I may use that, on our electoral process and the progression of democracy?
Well, I don't think that it would be right to call it delays, because what the tribunals and the courts are doing is they're acting according to the extant law. The extant law gives them a time frame, and they're acting within that time frame. But what has become a source of concern is whether this time frame is too long. But in the determination of whether the time frame is too long or not and the impact on governance, there are a lot of factors that needs to be taken into account. Nigeria is a country of about 200 million people, a country of 36 states and the Federal Capital Territory. So assuming that you are challenging a presidential election, you have a duty to prove that the election, for example, if the ground is that there was no compliance, you must show that there was no compliance that are substantially, which means affected majority of the 36 states and the Federal Capital Territory. And you know, that is not a tea party. It's not something that you can just do overnight. It will take some time.
Truly. Because of how concise the time is, I want to take you away from that part of the conversation, because we know that's an ongoing discussion, the honors to prove electoral fraud. So I'm going to ask you now, can the Supreme Court of Nigeria provide clarification on the timeline and procedures for handling election nullification cases to ensure timely resolution of electoral disputes? Could it be, from your explanation earlier, could the Supreme Court step in here and help make matters easier?
No, I don't think this is an issue for the Supreme Court. The law is that the responsibility to make law is that of the legislature. The responsibility of the judiciary, which includes the Supreme Court, is to interpret the law. So at this moment, the law is clear. There is nothing the Supreme Court can do other than to interpret. If there is need to take a second look at the time frame for the resolving electoral dispute, then it has to be resolved by the National Assembly, because it is a constitutional responsibility to make law, including amending the Constitution as in the instant situation.
All right. How can let's look for, some suggestions now. How can the Electoral Commission, INEC, improve its processes to minimize the likelihood of legal challenges like those brought by Atiku, Abubakar, and Peter Obi, and to ensure more efficient and credible elections in the future?
Well, on the part of the electoral empire, my view is that there is need to deploy more technology that will help in resolving election disputes, because in that case, when technology is involved, the question of trying to get the relevant materials may not be too much of a problem. Then the other dimension is that those who intend to go to court must get their materials ready, and not the situation that we are facing, because there are some issues that there's nothing the electoral empire can do, such as the situation we have at hand. But with respect to the electoral empire, I think that there's need to deepen the deployment of technology in the electoral process.
I mean, you need to be specific when you're talking about technology, because we know the challenge we're having with the IREV and transmission of results. What can INEC do to improve on the technology that we use? One hand is to improve on technology, on the other hand is to apply it in trying to determine cases like we have today. We see that the technology that was deployed is being questioned. So is there holes in the law that we need to fill in order to allow INEC actually be compelled rather, to use technology in conducting elections?
Yes, I think that's the dimension we should take it from. If you recall, in 2015, there's what they call the smart card reader that was introduced. But the issue with the smart card reader then was that it was in the electoral guidelines and not in the electoral act. And that was why the issue of using beavers was included in the electoral act. Now, there is a controversy, and part of the issues that the Supreme Court will resolve as to whether it is mandatory under the present Electoral Act for results and some other things to be transmitted. For me, the way to resolve it is for the National Assembly to clearly resolve some of those issues and make it mandatory for INEC to deploy technology, including voting. I think that we have got to the stage where we should introduce electronic voting, electronic recording of votes, electronic transmission of votes, and of course, all the process of election from the beginning to the end should be by way of technology, so that the human interference can be reduced.
Eric, thank you so much for speaking with us. We appreciate your insight.
Thank you. It's my pleasure.